Once again, with respect to 480, it does seem to me that Ms. Moss' comments really go to the weight rather than the admissibility. It shows Mr. Prentice, he's a party to the lawsuit. He was shown this video at his deposition, and I think that's a sufficient basis for its admission. Now, turning to 2681.
Yes, Your Honor. And perhaps what would make sense is, perhaps with 480 admitted, we could show the excerpts of 480 and then come back to the document that talks about the video.
Very well.
Okay. And Your Honor, with the court's indulgence, we would submit Exhibit 480A that will identify the exhibits that have been played.
Very well.
So, turning then to 2681, Your Honor. 2681 is an article about this video by the group that made it, the American Family Association. And we acknowledge this is not a document that was produced to us by the other side, but it's a document that we obtained from a website, onenewsnow.com. It's clearly attributed at the bottom of the exhibit. I don't think there's any dispute that American Family Association made the video, and this is a website.
It's American Family Association or American Family Council?
Association. Association, Your Honor.
I'm sorry?
Association, yes.
Association. What's the connection to the defendants of American Family Association?
Well, we do know that they donated, I think, $500,000 to the campaign, but I guess the most direct connection for these purposes is that they were making a video during the campaign, that they wanted to put it out to the people, and that included Mr. Prentice, who ran the campaign, talking to voters. We think, Your Honor, again, one point I would like to clarify, we're not, and we don't need to offer this article for the truth of any matter asserted. In fact, we disagree with what they are asserting, but we think that for the people who made this video, with Mr. Prentice's involvement and cooperation, to be characterizing what they're trying to communicate in the video is certainly relevant.
Ms. Moss?
Again, Your Honor, there is no evidence that this was put out during the campaign, and there's no evidence that Mr. Prentice was speaking on behalf of ProtectMarriage.com. I believe that he was identified in the video as the head of the California Family Council. Mr. Prentice himself is not a party in this lawsuit. He is only, his admission would be those if he was speaking for the party in the lawsuit, which is ProtectMarriage.com. And there's no evidence that when he gave this interview to this organization that he knew that it would be used for, that he knew what it would be used for, or that this in fact became something that was available to voters attempting to persuade them one way or another about Proposition 8. And this article, therefore, if they are offering the article to demonstrate that, then is hearsay. And that's an out-of-court statement offered for the truth of the matter asserted, which is they are asserting that some evidence in that article is proving something about this video. I mean, it's not clear to me that it does, but if that's what they are offering it for, then it's hearsay.
Your Honor, there is no doubt that this article was before the campaign. It's dated September 2008. And there's a reference on the second page that says, if Proposition 8 is not passed in November, okay, that's clearly before the campaign. And this is the people who made the video, making statements about the reasons that they are putting the video out.
Maybe Mr. Dusseault can direct me, but I don't know that this says that the video came out before the campaign, even if the article did. And again, the article may be dated 2008, but there's no evidence that it was posted on the internet at that time.
Well, Your Honor, the video is in evidence. The question whether an article by the people who made it talking about what they were trying to accomplish is something that you should be able to consider.
I'm going to sustain the objection. It seems to me that the connection to the parties in this lawsuit is sufficiently tenuous that there's no basis to admit 2681.
All right. Your Honor, then, I would move on to Exhibit 2589, which is in the same binder.
Very well.
Your Honor, Exhibit 2589 is an email from Mr. Prentice to a recipient who's blacked out, I believe in the interest of the protective order concerns, with the subject, "Wrong Again." And its attachment is called Top Proposition 8 Arguments. And this is something that was circulated in July of 2008 before the election. So it comes from Mr. Prentice, purporting to characterize top arguments in favor of the proposition that he's putting on the ballot and wants people to see.
Any objection?
No objection, Your Honor.
Very well, 2589 is admitted.
And if we could publish 2589, particularly the top Proposition 8 arguments. And I'd like to draw particular attention, Your Honor, to argument number 10, which reads, 10. What gays do in their private lives does not bother me, but I do not want children exposed to it. The next document I'd seek to move in, Your Honor, is just two documents. And what these documents do is establish a level of connection between ProtectMarriage.com and the National Organization of Marriage. And you may recall, Your Honor, that the National Organization of Marriage did that Gathering Storm video that's in evidence, and there was talk about involvement or lack of involvement in the campaign. I would like to introduce two documents that we think show a level of cooperation and coordination between ProtectMarriage.com and the National Organization of Marriage. The first of those is Exhibit 2597.
2597.
And Exhibit 2597, Your Honor, was produced to us by the defendant interveners, so there shouldn't be any authenticity issues. It's written and sent by Mr. Prentice before the election, so I don't believe there should be any issues as to the admissibility of 2597. And I would ask that it be admitted so I could publish the particular paragraph that we wish to address.
Hearing no objection, 2597 is admitted.
All right. Then on the last page of this exhibit, there's a paragraph that begins, "Never." And I'll just read this into the record, Your Honor. Never in California history has an initiative qualified without the help of paid signature gathering. This is where the cooperation of Bishop Cordileone and the San Diego Catholic community offered tremendous help. The bishop sought the help of the National Organization for Marriage, NOM, led by Maggie Gallagher, herself a Catholic, with a national reputation for her research and writing on marriage. Gallagher and NOM's executive director, Bryan Brown, assisted the bishop in articulating the critical need for a constitutional marriage amendment to hundreds of donors and the National Office of the Knights of Columbus, ultimately amounting to more than $900,000 in gifts directed to signature gathering. Okay, the second and final document I wish to address on this subject, Your Honor, is Exhibit 2455.
2455.
Yes, Your Honor. Your Honor, Exhibit 2455 was produced to us by the defendant interveners during the trial. It's a chain of emails. And the one on the first page is the one to which I would like to draw the court's attention. It is, I believe, from Maggie Gallagher to Bryan Brown, who was identified in the previous document. Also to Frank Schubert of Schubert Flint with a CC to Mr. Prentice. And this is before the election. So again, we think there's no issues as to the authenticity or relevance. I would move it into evidence.
Hearing no objection, 2455 is admitted.
Thank you. And then if we could put up on the screen, Chris, the sentence beginning, "We're going." Okay. And this sentence appeared to be written by Brian Brown of the National Organization of Marriage to Mrs. Gallagher. And this is now shared with Mr. Schubert and to Ron Prentice. And it says, it's talking about, let me give some background here. You see at the bottom of the email, there's a, well, it looks like a press statement. It says, Hollywood stars, ACLU pour money into anti-marriage efforts in California. And what Mr. Brown is saying is, we are going to need to get approval from Schubert Flint on this. The text of the agreement requires anything specific to California to get approved.
Your Honor, while we didn't object to the document coming in, that specific statement itself, we believe, is hearsay and should not be considered as such continued, since it is an out-of-court statement that they are offering for the truth of the matter asserted.
I believe the document's already in evidence at this point.
The document is in evidence. The question is what to make of it.
Well, Your Honor, I think it should be admitted as substantive evidence. But certainly, even as a matter of state of mind, if Mr. Brown from the National Organization of Marriage is under the impression that he has an agreement with ProtectMarriage.com where he has to run all of his messages by them, that in and of itself, I think, is probative and relevant.
Well, Your Honor, that's precisely why it's not appropriate for this to come in. He's making inferences about the state of mind of an individual that's not on the stand. And we can't examine as to whether this was, in fact, what he understood or what he intended when he wrote the statement. I mean, it may have a totally different meaning. We don't have a context of it. And since they're moving this in without a sponsoring witness, there's no way to have that context. And so that statement itself should not be taken into evidence because it is hearsay.
Your Honor, it isn't hearsay if it's state of mind. It's not offered for truth of the matter asserted.
Well, the question is how much weight to give to the evidence and exactly what to make of it. It's clearly an admissible document. This may be one of the reasons why the proponents wish to call Mr. Schubert.
Very well. Okay, Your Honor, the next two documents relating to the campaign are on a related topic, which has to do with sort of the breadth of the network and support that ProtectMarriage.com had. The first document on that point is Plaintiff's Exhibit 2660.
2660, okay.
And Your Honor, again, I'm not really clear what the objection is to this document. It's written and sent by Mr. Prentice before the election, and it's produced to us during the trial by the defendant interveners. So I would move the document into evidence. And then once it's in evidence, I'd like to publish a portion of it to address.
Hearing no objection.
No objection. Well, I'm sorry. The tender of this was, you believe it shows? Our only objection to this is that we weren't sure what relevance they were attaching to this document. And I'm not sure that I caught what he's claiming the document purports to show.
Well, it talks about having the strongest grassroots response in the history of the California initiative. And it goes through some of the people who make up that response.
Well, it's a document from Mr. Prentice, the chairman of ProtectMarriage.com. It's therefore admissible. 2660 is admitted.
Thank you. If we could publish the bold portion at the bottom. And in this message sent by Mr. Prentice, what he says, he describes his campaign as the strongest grassroots response in the history of the California initiative. He talks about the role of the evangelicals, the Catholics, the Latter-day Saints, the Orthodox Jewish communities. And then at the bottom, he references something called the Arlington Group, which is described as 60-plus organizational networks with special offerings nationally. So what we believe this document is describing is not just the religious groups, but also this entity, the Arlington Group, that brings together 60 additional organizations. And then, Your Honor, the second document on this subject is 2385. 2385, Your Honor, was produced to us by Mr. Swardstrom, who you may recall is one of the executive committee members who we had a dispute about the depositions and production of documents. He attempted to keep his identity secret for quite some time during discovery. But when his identity was actually disclosed, we did get some documents from him. And I would draw to your attention, Your Honor, to the email on the first page. It's from Catherine Snow of the Arlington Group to a number of recipients, including Mr. Prentice. And we believe, Your Honor, that this email, that it is something that's sent during the campaign, August 2008, to Mr. Prentice, although not produced by them, is something that is properly admissible into evidence. And we would ask that it be moved in.
Again, Ms. Snow's email is, she is not a party. And so again, we would contend this is hearsay. We don't dispute that this apparently came from Mr. Swardstrom's files. But the portion that they're seeking to go offer in, or what this reflects, is an email from somebody outside the campaign sending it in. And it's not clear which particular statements he's pointing to, but presumably they are hearsay since they are not from a party.
Nonetheless, it's a communication to Mr. Prentice, and therefore 2385 will be admitted.
Then, with Your Honor's permission, we would show the portion, publish the portion, which refers to a website. And this is, as Ms. Moss noted, this is someone from the Arlington Group talking about what they're doing here as part of this effort. And what it says is, I am organizing heavy hitters to do video clip messages to the American public to promote our efforts. Newt on board, emphasis social fabric. Requests out to Mies, plea to legal community. Levin, plea to country. Dobson, plea to Christians. Pastor Garlow, plea to all pastors. Mike, Judge, Colin Hart, UK, warning of what will happen if apathy steps in and what UK now faces. And the House with blunt Rep. Pence, Senator Burr for plea to elected officials.
Your Honor, I would again just note these statements as to what the Arlington Group are supposedly doing or not doing are out-of-court statements being offered for the truth of the matter asserted. It hasn't even been established that these are efforts. My understanding is they were also involved in the ballot initiatives in other states. And so to what extent this is even pertinent or applicable to California, I don't think has been established. And Ms. Snow, the author of this document, she's not here for us to question, to get to the content and to cross-examine her about this statement.
It's a document was sent to Mr. Prentice, certainly would reflect his state of mind, therefore it's admissible, it's in.
Thank you. Your Honor, the last document we have on the campaign messages group, I don't believe there will be, or will likely be any issue with this because this is actually one that's on their Schubert list that they intend to use. But it's Exhibit 2150. This is an actual flyer from the campaign itself that was produced by the defendant interveners to us. Seems to be clearly admissible as campaign material, and I don't understand what the basis would be to object.
There is no objection. I don't know if that was on our list or if we just overlooked it.
Very well, 2150 is admitted.
Okay. Then, Your Honor, the last group of documents, which I think I can do very quickly, we have a final set of binders on this group of documents. It's documents that relate to subjects of testimony that we have already had in the trial but are not currently in evidence, that we just hoped we could just move in by agreement, but we have some disagreement over. Now, Your Honor, the first two of these documents that we hope to admit into evidence are Exhibits 1675 and 1676. And these are two statements of the American Anthropological Association on the issue of race. We believe, Your Honor, there's no dispute between the parties that these are in fact true and correct copies of official statements of the American Anthropological Association on the subject of race. And I would submit, Your Honor, that this issue is directly relevant to this case because of an argument and a line of questioning that the other side has been making that somehow sexual orientation is some undefinable minority status, whereas something like race is quite clear and defined. And what this document, both these documents do, is address what anthropologists recognize as the complexity of the concept of race. And we would note that this doesn't include protective status being afforded to members of racial minority groups.
Ms. Moss.
Your Honor, I don't have these down on the list of what we reviewed, but looking at them quickly, that was presented to us for review. Looking at them quickly now, we think that the court could take judicial notice of them, so we wouldn't have any objection to that extent. We think it probably would have been more appropriate for an for an expert to come and speak to them, but they can be taken judicial notice of, certainly.
Very well, I think that's correct, and therefore the court will take notice of 1675 and 1676.
So what I'd like to do, then very briefly, Your Honor, is publish Exhibit 1675 and draw the court's attention to a couple of passages. Chris, if we can start with the very first paragraph. In the United States, okay, and the two sentences to which I want to draw the court's attention are, in the United States, both scholars and the general public have been conditioned to viewing human races as natural and separate divisions within the human species based on visible physical differences. With the vast expansion of scientific knowledge in this century, however, it has become clear that human populations are not unambiguous, clearly demarcated, biologically distinct groups. Okay, and on the second page, if we could publish the paragraph beginning at the end. And here, the American Anthropological Association says, at the end of the 20th century, we now understand that human cultural behavior is learned, conditioned into infants beginning at birth, and always subject to modification. No human is born with a built-in culture or language. Our temperaments, dispositions, and personalities, regardless of genetic propensities, are developed within sets of meanings and values that we call culture. Studies of infant and early childhood learning and behavior attest to the reality of our cultures informing who we are. And then finally to the last substantive paragraph, beginning, how people. And here the American Anthropological Association says, how people have been accepted and treated within the context of a given society or culture has a direct impact on how they perform in that society. The racial worldview was invented to assign some groups to perpetual low status while others were permitted access to privilege, power, and wealth. The tragedy in the United States has been that the policies and practices stemming from this worldview succeeded all too well in constructing unequal populations among Europeans, Native Americans, and the peoples of African descent. Given what we know about the capacity of normal humans to achieve and function within any culture, we conclude that present-day inequalities between so-called racial groups are not consequences of their biological inheritance, but products of historical and contemporary social, economic, educational, and political circumstances.
Very well.
Okay. Your Honor, the next two documents that we'd seek to move into evidence are 2566 and 2581. If we could just start with, let me start with 2581, Your Honor. And Your Honor, these are documents that we obtained from a website called the Katami Papers. But each of the underlying documents can be found in the Library of Congress and is admissible evidence under the ancient records exception. And this first one is a communication to the Pride Foundation, in which the Treasury is denying an application for tax-exempt status for a group that seeks to further the rights of gay and lesbian people. We would submit, Your Honor, that this document is admissible and is relevant to the issues of the history of discrimination that gay and lesbian people have faced, and also to the question of relative political power.
This is a document from 1974,
That's true.
and you are characterizing this as an ancient document?
Well, don't shoot the messenger, Your Honor. I think it's the rules of evidence that say 20 years or more.
Very well. Ms. Moss.
Your Honor, the hearsay objection aside, the source of these, as he noted, is a website. It may be that these are obtainable from the Library of Congress. I don't know. What they've given us is something that is printable. What they've given us is something that is a printout from a website. And there's no way to verify. I don't know this website. I mean, they haven't put anybody up here to explain where the individual who controls this website obtained these documents. So there's really no way to know that they are, in fact, authentic copies of what would be in the Library of Congress. And for that reason, we would object that the authenticity has not been established.
Library of Congress maintains documents such as this?
Apparently so, Your Honor. And to be clear, the underlying document, we're not suggesting that the website page, which is intended to show where we got it, is in the Library of Congress.
You did not obtain the IRS letter from the Library of Congress?
Okay. Your Honor, Mr. Olson is reminding me that we did actually, anticipating this concern, go and make sure that we could obtain it from the Library of Congress, that this document can be obtained from the Library of Congress. The copy that we had included on our exhibit list was one that we obtained from the website, but we have researched this, and perhaps what we could do, Your Honor, is admit it into evidence, subject to qualification of its...
Well, I will accept counsel's representation on that basis, and it'd probably be well to verify that. But what lawyers say in making factual representations to the court assumes the accuracy of their statements and holds lawyers accountable. So based on your representation that this is available from the Library of Congress, this letter dated October 8th, 1974 to the Pride Foundation of San Francisco from the Internal Revenue Service will be admitted. So that portion of 2581 will be admitted.
Thank you, Your Honor. And then, if we could publish the letter, and on the page numbered beginning, based on the foregoing. What I would read at this point, Your Honor, is from the letter denying tax-exempt status to the Pride Foundation. It says, based on the foregoing, we feel that your activities are advancing the unqualified and unrestricted promotion of the alleged normalcy of homosexuality. Thus, we conclude that your activities carry a serious risk of contributing to a more widespread development of homosexual tendencies among certain segments of the public. and a consequent increase in the general prevalence of what is still generally regarded as deviant sexual behavior. As such, your activities are contrary to public policy and are therefore not charitable. And the second document, Your Honor, is Exhibit 2566. And Exhibit 2566, Your Honor, is also from the same website and can also represent that it's obtainable from the Library of Congress. And I apologize for the quality of the print, especially on that first page. But what this document is, it's from the United States Civil Service Commission, and it is a document written in 1966 explaining the government's policy against having gay and lesbian individuals employed in civil service. And we would move the document into evidence under the same terms and reasoning as the prior document.
Well, based on your representation, this document is to be found in the archives of the Library of Congress and is therefore an official government record. 2566 will be admitted.
Okay, thank you, Your Honor. Now, Your Honor, the final group of documents that I have to address is a
Is there any particular portion of the United States Civil Service Commission letter dated February 25th, 1966 that you wish to draw the court's attention to?
Yes, Your Honor. Give me one moment.
And what is being admitted in 2566 as with 2581 is simply the government letter rather than the Katami papers portion of the documents or portions of the exhibit?
Yes, Your Honor. Your Honor, on, and again, I apologize for the quality of the copy. On page 2 of the exhibit, of particular note here, is where, in explaining the policy, the author talks about, quote, considerations that encompass the types of deviant sexual behavior engaged in whether isolated, intermittent, or continuing acts. The age of the particular participants, the extent of promiscuity, the aggressive and persistent character of the individual's participation.
Keep your voice up, counsel.
Oh, I'm sorry. Sorry, thank you. I'm looking very closely at this page. The recency of the incidents. And then it goes on here, Your Honor. And what I think is particularly noteworthy is this document it essentially justifies the policy by denying the concept of a homosexual as a person or individual, and rather focuses on the conduct as a justification, and says because this is talking about conduct, it is a sufficient basis to exclude people from working for the government.
Well.
Okay, Your Honor. The final category of documents I seek to move in is a slightly larger number, and I thought what might be helpful is to describe generally what it is. It's a couple of groups of data that we believe are relevant to understanding some of the testimony, particularly for Professor Badgett and some of the questions that she was asked about Europe and other areas. You may recall, Your Honor, that counsel for the defendant interveners brought in cross data from Europe that we hadn't seen, and it had not been disclosed to us before because they don't have to disclose their cross documents, and they asked some questions about those things. And what we have done is collected some additional data that we think would be helpful to have in the record, so that when we were arguing from the testimony of the experts, the actual underlying data is also part of the record. So, Plaintiff's Exhibits 2823 through 2829 in your binder, Your Honor, are examples of data from Europe, coming from something called Statistics Netherlands, which is, I believe, the exact source that the defendant interveners relied on for their cross-examination. And this is simply additional data that we think would be helpful to have on the record. So I would seek to move into evidence Plaintiff's Exhibit 2823 through Plaintiff's Exhibit 2829.
Can you represent that these came from the official website of the government of the Netherlands?
Yes, Your Honor, we can.
Ms. Moss?
I'm trying to find which exhibit this is, Your Honor. I think we have no objection to most of these, but I think there is one one exhibit, and I believe that it's 2829, that deals with birth rates, or maybe with non-parental birth rates. That was not something that I think was introduced with Dr. Badgett, so I don't think it's appropriate, and it doesn't go to anything that they testified to. The marriage statistics are, we don't have an objection to the marriage and partnership registration statistics.
Your Honor, I'm seeking help from my team to see if we can figure out which is the birth rate document.
2829, it appears.
Okay. And Your Honor, we believe that the defendant interveners did, in fact, raise the issue of non-marital birth rates in their cross-examination.
I believe that's correct, and there being no objection to 2823 through 2828, they are admitted. And to the extent that there is an objection to 2829, it is overruled and 2829 is admitted. These appear to be government statistics.
Thank you, Your Honor. And then two other documents of data I don't think we'll need to spend too much time on because they're from the defendant interveners exhibit list. DIX 1836 and DIX 2627.
DIX, I'm sorry? It's DIX.
Yes, at the end. It's at the end, Your Honor. 1836 and 2627 are the last two tabs in your binder. Again, this is data about divorce rates.
I have it in binder 1836, but 26,
You do not have 2627 in the binder?
is that a PX or a DIX?
Give me one moment, Your Honor. Okay, Your Honor, to the extent that it was omitted from the binders, we have handed out, that was inadvertent. I can show it to Ms. Moss and pass a copy up to Your Honor.
Very well.
We have no objection to these exhibits, Your Honor.
That would appear to solve the problem.
And Your Honor, the final documents in this category are Plaintiff's Exhibit 2345 and 2346.
25
No, 2345 and 2346. And these, Your Honor, are documents from the Center for Disease Control national data regarding health statistics. 2345 pertains to national marriage and divorce rate trends from 2000 to 2007. And 2346, marriage rates by state, 1990, 1995, and 1999 through 2007. And again, Your Honor, I think the issue of marriage and divorce rates is data that's relevant to the issues we are talking about, given some of the arguments that the defendant interveners are making.
We would say that we think it would be appropriate for the court to take judicial notice of these.
Well, these are.
They are governmental records, Your Honor.
They are governmental records, and therefore I think that they are admissible.
Okay, so Your Honor, that concludes my presentation. If I could make two final notes. One is, as someone said earlier, plus whatever is on this note that I was handed. Sorry. There's one issue that I wanted to raise, Your Honor, which is that we have received for the first time about 100 additional documents last night at about 11:30 p.m. We haven't had a chance to look at whether there is anything in that we wanted to move in, and I didn't want to upset the order of what I had going in this presentation to try to deal with that. So we would certainly reserve any right we may have as to those very late produced documents. Lastly, It appears that there may be one document that I may need to clear up. And also, Your Honor had asked for some direction about the admissions. If perhaps we could take our morning break and I could come back and close that loop, I'll be done.
Sounds like a good idea. We'll take until 5 minutes of the hour.
Thank you, Your Honor.
Very well, Mr. Dusseault.
Thank you, Your Honor, and thank you for the break. I think I have 2 items that I can wrap up pretty quickly. The first is, Your Honor had asked if we could direct Your Honor's attention to particular admissions that were of importance, and what I would suggest is the following. Since we owe Your Honor some sub-exhibits on other issues where we have identified excerpts, we would suggest that we submit along with those what we would call 693A, that would identify what portions of exhibits we are particularly directing the court's attention to. If that's acceptable to Your Honor, we'll do that. If you would rather have it written out before we close, we will do our best to walk through it.
I think that's acceptable, subject, of course, to any amplification.
No objections?
Or clarification that the defendants may wish to offer.
Okay. And then the last point I have been asked by my team to raise, I mentioned the 100 documents that we received last night. We also received last night at 11:30 a privilege log with 7,500 documents listed. And I'm told that about 1,500 of those have been on a prior privilege log, but about 6,000 are documents that are being described to us for the first time ever. And we wanted to simply raise the matter to the court and identify the fact that if we have an issue with whether those are truly privileged, and we wind up fighting over that and giving them, in getting those documents, there may be a need, even after we rest, to introduce some of those withheld documents into evidence.
I thought that the magistrate's order had required production to be completed a week ago. Is that not correct?
Production, yes. But the privilege log, I believe, is what we're now getting. And there's documents described that because they are claiming a First Amendment privilege that we have never seen.
Yes, Your Honor. We had until yesterday to produce the privilege log. So after we finished and completed our production, we went ahead and then put together this privilege log, which was, we did a notice of filing and a motion to file it under seal. And we produced, under the protection order, attorney's eyes only, to the other side, a non-redacted version of the protective order.
Did the magistrate give you until yesterday to produce the privilege log?
Yes, Your Honor.
Okay. I think the privilege log should be due when the documents are due, but if that's what the magistrate did and you're complying with it, well, that's fine.
And I'd also like to clarify, there was a small number of documents that were produced. I think it was 14 or 15 documents, and it was simply ones that in finalizing the privilege log we determined should not have been on there. And so, of course, in due diligence, produce them to the other side.
And Your Honor, our point would simply be to preserve our position that if there were documents produced for the first time last night or described to us under a privilege log for the first time last night, there may be need to come to Your Honor even after we rest and present documents that were not available to us in sufficient time to use them.
Well, I assume under these circumstances, the defendants will not object to a motion to reopen based upon this additional production. You may very well contest whether these documents should be produced or not, or should be introduced or not, but I wouldn't think you'd be in a position to argue that the plaintiffs are precluded from attempting to reopen if necessary.
We would not have an objection, provided that it was ultimately determined that some of these documents were not privileged. that if they had not come into evidence, we would have the opportunity to respond as well.
Very well.
I'm sure we can deal with the mechanics of it.
Very well.
Thank you then, Your Honor. I will hand over the reins to Mr. Boies.
Very well. Mr. Boies.
Purely ceremonial, Your Honor, subject to the qualifications that have already been expressed. The plaintiffs rest.
Very well. Mr. Thompson.
Yes, Your Honor. The defendant interveners would like to call Professor Kenneth Miller to the stand.
Please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please be seated. State your name, please,
Kenneth P. Miller,
and spell your last name.
Miller.
And your first name?
Kenneth, Kenneth.
Thank you, Mr. Miller.
And, Your Honor, we would like to start with a bit of housekeeping. We have a list of exhibits that were materials that the professor relied upon, and we sought plaintiff's consent to move them into evidence. We've been told that they have no objection. I have a list I would like to tender to the court, if I may.
Very well. Thank you, Mr. Thompson.
In addition, I think that tender may obviate the need for using this binder very much, but may I approach and hand out one binder?
By all means.
Thank you, Your Honor. Professor Miller, where did you attend college?
I attended college at Pomona College.
And after college, where did you attend graduate school?
Immediately after college, I went to law school at Harvard Law.
And after graduating from Harvard Law School, did you practice law?
Yes, I did.
And which firm did you practice upon graduation?
I practiced with the firm of Morrison and Forster.
And for how long did you practice with Morrison and Forster?
I was with the firm full-time for 5 years. I was originally hired in the Los Angeles office of Morrison and Forster. Spent 2 years there in the litigation department. Then when the firm opened a Sacramento office, I was one of the 3 lawyers that went to open the firm there, and I was there for about 3 years in Sacramento. Then after I left full-time employment with the firm, I was also with the firm on a contract basis for a couple years as well.
And what sort of cases did you work on while you were in the Sacramento office?
In the Sacramento office, we were doing some regulatory work, represented a number of clients, including the San Francisco airport, other major corporate clients that had business before the state government.
Did there come a time when you went back to graduate school again?
Yes.
And what further degree did you pursue?
I pursued a PhD in political science.
At what university?
At the University of California, Berkeley.
And when did you receive your PhD?
In 2002.
What is your current position?
I am an associate professor of government at Claremont McKenna College.
Is that a tenured position?
Yes, it is.
And before receiving tenure, what was your position?
For 6 years, I was an assistant professor in the government department at that college.
And have you had any teaching positions before you arrived at Claremont?
Well, for 1 year, I was a visiting assistant professor. This is immediately before I went to Claremont at the University of San Francisco.
And what activities did you perform in connection with your position in the Department of Government at Claremont?
So, like most faculty members, I have a range of activities. I have active research work that I do. I'm also, I have a full-time teaching load. I serve on various committees at the college, and I'm also the associate director of a research institute at the college.
And what was the name of that research institute?
The Rose Institute of State and Local Government.
And what did you do in connection with your working at the Rose Institute?
The Rose Institute studies state and local politics, mainly in California, but also in other states. I supervise a lot of the research, particularly in the areas of redistricting, fiscal analysis of state and local governments as well.
What courses do you regularly teach at Claremont?
On a regular basis, I teach Introduction to American Politics. I also think that every year I teach a class in California politics. Every year that I've been there, I also have taught a senior seminar for seniors in the government writing honor thesis. Almost every year I teach an undergraduate class in constitutional law, which would be either national powers or civil rights and civil liberties.
Now, in your course on California politics, what subjects do you cover?
We cover a range of topics relating to state government, starting with the founding of the state back in 1850, the original Constitution up through the Progressive era, and the introduction of initiative, referendum, and recall in the state 100 years ago. Then I fairly quickly move up to the 1960s, the Pat Brown era as governor, and talk about the professionalization of the state legislature. We're moving at that point into the institutions of state government, which are distinctive in California with a term limit legislature, a powerful initiative process, the state judiciary, and the executive branch with its separately elected officers. In addition, I cover a lot of material about the change in demographics of California and how that's affected the political makeup of the state, the incorporation of racial and ethnic minorities into the political process, as well as the partisan shifts of the state from being essentially a 50-50 Republican and Democratic state to a majority Democratic state. And finally, I have the students look at the particular policy issues, either the state budget or policy issues, and they do in-depth research projects on those issues.
In the California politics course you teach, to what extent, if any, do you address Proposition 8?
In my section where I'm looking at state institutions, direct democracy, and courts, I have for the last several years done a unit on Proposition 8, the relationship between Proposition 8, Proposition 22, in remarriage cases, and the conflict between the people and the courts over the definition of marriage in the state of California. So it's at least 2-3 courses in the class, which is a fairly large chunk of my syllabus.
And in your class on California politics, to what extent, if any, do you address California's domestic partnership laws?
In connection with that discussion I just described, I offer the domestic partnership laws as the legislature's contribution to this controversy over legal recognition of same-sex couples. So we definitely talk about the original domestic partnership law in 1999 and how it was augmented over time.
And in your class on California politics, do you address the role of gays and lesbians in the California political landscape?
Yes, we do, in a couple of different ways. One is in the context of this controversy over marriage in California, and also more broadly, when we're discussing the coalitions that support the two political parties in the state, with gays and lesbians being an important coalition partner for the Democratic Party in the state.
Do you address the political power of other minority groups in your class on California politics?
Yes. As I mentioned, we discussed the incorporation of various minority groups into the political process, the transition, especially for immigrants to becoming citizens, then the additional steps of getting registered and voting and participating in the political process. There's literature on that that I have the students read, and then we discuss that in class.
All right. Now, in your American politics course, to what about extent, if any, do you discuss the political power of minorities in the United States?
Well, for as long as I have been teaching this class, a central theme of it has been the issue of racism in the United States, going back to prior to the founding of the Constitution, the institution of slavery, the debates over slavery in the original Constitution. The period leading up to the Civil War, the Dred Scott decision, the Civil War that followed, Abraham Lincoln's speeches in this area, the post-civil rights, the post-war Reconstruction amendments, and then the period of segregation up through the civil rights movement all the way up to President Obama. So it provides sort of a trajectory showing how a particular group in our society faced discrimination and was able to achieve civil rights over a period of time.
And to what extent, if any, do you address prejudice against African Americans in your course on American politics?
It's a central theme of what I have just described. Oftentimes, I have assigned a book or portions of a book called Simple Justice by Richard Kluger that certainly addresses the issues of prejudice against African Americans. The book is a discussion of the Brown versus Board of Education case, but it goes back to the origins of slavery in the United States, and it traces the history of discrimination against African Americans in the United States up to and even after the Brown versus Board decision.
And to what extent, if any, do you teach in your course on American politics about the political power of gays and lesbians today?
In particular, when we're talking about political coalitions in the state and the two-party system and how the parties form coalitions, we discuss gays and lesbians as being, again, an important part of the an increasingly important part of the Democratic coalition in the United States.
Now, you also mentioned that you perform scholarly research and writing. What is the main focus of your scholarly research?
Okay, so this goes back to my time as a graduate student at Berkeley. The central focus of my research from then until the present has been direct democracy and the initiative process, in particular in California and in other states. And in that original work as a graduate suitability, I applied what I considered to be a pure Madisonian critique of direct democracy and the disadvantages, in my view, that it had compared to representative government. And I wrote a couple of articles at that time which were on that theme, and it was also it informed my dissertation that I wrote at Berkeley. That was in 2002 that I filed my dissertation, and the articles were in approximately that period, 2001 or so. But I have continued to be interested in this problem of direct democracy in a constitutional system, and I wasn't fully satisfied that I had really gotten as much to the nub of the problem that I would like to. So after I finished my dissertation and PhD, I decided to have that be my continuing research focus as a scholar. So in the years since I've done, I have greatly expanded my research in this area. I now have a database which I have collected that has information on all voter-approved initiatives in all 24 states that have the initiative process, not just California, but other states, from the beginning origins of the initiative process in the early 1900s until the present. And based on that research and a lot of historical research going back to the progressive era, I started to sort of modify my views a little bit from where they had been as a graduate student. In particular, I had I have a somewhat more favorable view of direct democracy in my work at this point, and I see it now sort of as a way in which the people can exercise popular sovereignty in our constitutional system. The other thing that I have come to conclude is that direct democracy, which provides an emphasis on popular sovereignty, has often come into conflict with the courts or the judicial power going all the way back to the progressive era.
Perhaps you should tender the witness before he begins opining.
Yes, Your Honor. We will just do a few more questions on his background before we get into a substance. What is the name of your current book on the subject?
Okay, yeah. My book is called Direct Democracy in the Courts, which was published by Cambridge University Press in August of 2009.
And does that book address Proposition 8?
Yes, it does.
And you've also written a book, The New Political Geography of California. Is that right?
Yes, I have.
And briefly, what's the general thesis of that book?
Well, the book is a collection of chapters. It's one of these things, it's an edited volume, and I was one of 3 editors of the volume. And we had various different contributors who were looking at critical change in California from a geographic perspective, geographic as well as a demographic perspective. The main thesis of the book is that California shifted from a predominant north-south partisan divide, with the north being more liberal and the south being more conservative, to an increasing east-west partisan divide, with the eastern part or inland part more conservative and the coastal region more democratic. Overall, the state has become increasingly democratic over the last generation. So that the book, in various different ways, explains that change both at the statewide and local level.
And when was that book published?
I believe that was in 2008. The book was published by Berkeley Public Policy Press, which is an imprint of the Institute of Government Studies at UC Berkeley.
And to what extent, if any, have your journal articles focused on the political issues relating to the political power of gays and lesbians?
Well, a recent journal article I wrote for a French journal on American politics focused on the Proposition 8 campaign and my analysis of some of the reasons why Proposition 8 was unable to pass even in a state that elected Barack Obama in 2008.
All right. And have you given any presentations at conferences that relate to the political power of gays and lesbians?
Proposition 8 passed, did not pass?
Oh, I'm sorry. One of the reasons Proposition 8 passed. I was misstating. Thank you, Your Honor.
I think maybe we understood what he meant.
Thank you, Your Honor. And so you given any presentation at major conferences on issues relating to the political power of gays and lesbians?
Yes, I have.
And please describe them briefly.
Okay, I have presented twice at the annual meeting of the American Political Science Association, which is the largest meeting of political scientists in the United States. The first time was in 2005. I was on a panel. This was following the Goodridge decision in Massachusetts, and there were a number of panelists that were analyzing the probable impact of that decision. And I presented a paper on the Goodridge decision and its probable impact at that conference. The second time was last year in Toronto, another meeting of the APSA, and I presented, I was actually on a roundtable discussion with a number of scholars who focused on the question of the relationship between courts and direct democracy and the controversy over same-sex marriage in the United States.